Good afternoon, everyone, and welcome to the International Human Rights Law panel. My name is Sanada Aliou. I study Masters in Criminal Law, and I'm very honored to be your moderator in this panel. As a well-accepted definition of international human rights law, it would be considered the body of an international law designed to promote human rights on social, regional, and domestic levels. Unfortunately, these very important rights are not protected and often violated in the Islamic Republic of Iran. The government of Iran is criticized both for restrictions and punishments that follow the Islamic Republic's constitution and law by Iranians itself, activists, and various international NGOs. In the current events of a possible constitutional change in Iran, now more than ever, it's of importance to discuss the state of human rights in the Iranian legislation and the need and possibility of a change. Without wasting any more of your time, I'm going to continue the short introduction of the topic with a presentation of our panelists, who I can assure you will make the subject even more interesting for you. Starting with Dr. Mahmoud Masaeli, Professor of Human Rights, Global Ethics and Development, founder of the global think tank Alternative Perspectives and Global Concerns. Welcome.
There's a little change in my talk because I've been in this conference from today, and I decided to a little adjust my talk. Two quick notes. I remember Thomas Pogge was asked why you are labeled as a radical cosmopolitan thinker. And he said, no, I'm not radical. No, not just radical. Because there are too many norms available right now in the field of international law relations that we can explore them in favor of the suppressed, marginalized people, and so on. And later on, again, I remember that John Rawls was labeled as a utopian thinker. Rawls said, no, I'm not utopian. Perhaps you can call me a utopian realist thinker. I believe in certain kind of utopia that can be realized. It just came to my mind to look at my own presentation somewhere. It's called Erga Omnes. I want to talk about Erga Omnes, obligations. The term is not known for the Iranian intellectuals. Basically, they do not know those terms. The idea simply is that there are certain kind of norms or principles that are superior and stand on the top of the hierarchy of international obligations. These are called erga omnes, obligations. Erga means toward, for all members of the international community, related to the benefits of the international community, and omnes means obligation. So erga omnes obligations, at least etymological aspect, when you look at the term, it says that there is a certain kind of obligations, not duties. Obligations are different from duties. Those are the obligations that must be followed by all members of the international community. So if you look at the term, if I can call it a term, it's not a term, it's more than a term. It's a kind of huge approach or perspective. And especially if you follow the roots of the erga omnes obligations by exploring jus gentium in the Roman law, and then you follow that route towards 17th century, 18th century, and you follow especially Hugo Grotius, and then prepare yourself to come to a newer time, right after the Second World War. This idea was confirmed by the international community that beyond the consent of the states or the contractual duties incumbent upon the state, there are certain kind of norms that you must obey without any condition. You must comply with without any reservation. Behind that idea, we can explore some examples. For instance, if you look at the principle of known as jus ad bellum, jus in bello, for example, both of them, non-use of force, or prohibition of genocide, or discrimination against women, and so on. If those principles are violated, those who violate them are responsible for something that they have done as a criminal thing. These are called international criminal wrongful acts by the states. Erga omnes obligations says that if one state acts in a wrongful way against the others, for example, in the field of human rights, massively, for example, massacre people or suppress women in Iran, etc., etc., the responsibility that's created for the state is a kind of international responsibility defined in terms of international crime. And the international thing at the center of the crime is that the criminals, those who act that kind of criminal actions, are responsible toward the international community. So that responsibility is called erga omnes, obligations known as erga omnes responsibility. So what happens is that those criminals who disregard erga omnes obligations, they are responsible toward the values, toward the norms that are superior in the international life for everyone. That means that if, for example, the government of Iran, of course we don't have a government, it is called the government. If the government of Iran is doing something toward the believers of the Baha'i faith, for example, and you suppose that the Baha'i people say that, okay, we ignore that, that is fine, okay, we forgive you, go ahead. International community says that no, it is not impossible to leave them alone because of the importance of the erga omnes duties. Those who act on that criminal way, they should be taken responsible by the international community. That is the essence of that. It is a little complicated. In the bindiness of the erga omnes obligations goes on the top of the hierarchy of all. On the bottom line, you can see, for example, declaratory duties by the states. For instance, you have the Universal Declaration of Human Rights that says this or that. That those of, if I can say, declaratory obligations or duties are basically voluntary, moral, lack of any kind of legal binding force. If you come one level higher, you reach the contractual duties, legally speaking. That says that the states that are party to a treaty, to a convention, they should obey. They should comply with all terms in that, for example, convention. If you go one level higher on the top, you will explore the erga omnes obligations. Erga omnes obligations, then I want to repeat again, assumes that there are certain kind of norms that are related to the values that are highly important for all members of the international community, not the international system of states. No, I'm not talking about that. They're two different things. International community. So erga omnes obligation, beyond all doctrinal, historical things that I do not have time to go through, that very complicated topics, have been several times confirmed via the International Court of Justice, via the judicial practices. If you're interested, for example, you explore Barcelona Traction Power and Light Company case in 1970. Or if you look at, for example, the Namibia case, the continued presence of South Africa in Southwest Africa. Or if you look at the East Timor case, or if you look at the military or paramilitary operation by the US in Nicaragua, there are several cases. International Court of Justice, via its own judgments and consultative opinions, there are two different things, confirm in all these cases. There are around 8 or 10 cases that they can list for you. International Court of Justice confirmed that all members of the international community, especially states, they should comply with the voice or the message of ergonomist obligations. International Court of Justice notably mentioned, if you are interested, for example, look at the Namibia case and look at the consultative opinion of Jose Alvarez, a prominent international thinker. He said that, listen, ergonomist obligations, you cannot avoid at all from them. You have to accept them. And if you violate, you are responsible. And as a result of your responsibility, universal jurisdiction must apply to you, because ergonomist obligations, at the center of that, there's a kind of must, a kind of ought. It should be like that. The International Court of Justice, for example, in the Barcelona Traction case of 1970, formally announced that all members of the international community must comply with all aspects and elements of ergonomist obligations. Later on, I remember that in the last cases that I read, the last one was the case by Gambia against Myanmar about the Muslims of, what is the name of the Muslims in Myanmar? I forgot the name. Rohingya. The court announced in 2020 that even in today's world, the lawyers, international thinkers, must prepare themselves and argue that the force of ergonomist obligations even can be explored via the treaty-based duty of the states. Sorry, I'm using technical terms because I have to use it. In the last case, Gambia versus Myanmar, the court said that at the center of the ergonomist obligations, you can favor a specific interpretation or extensive interpretation of the ergonomist obligations called ergonomist parties, T-E-S in the end, not T-I-E-S. Parties is specific there. And that says that even, for example, if you look at the Charter of the United Nations, if you look at the preamble, first paragraph of the Charter, or if you look at, for example, Article number 1 of the Charter of the United Nations, all states that are the member of the United Nations, based on their own commitment to the Charter of the United Nations, they are obliged to confer and accept that ergonomist obligations must be respected fully and carefully. Something like that. I will just summarize it and then go. International Law Commission, in his recent works, because the International Law Commission, as you know, is the most valuable, authentic gathering of international law thinkers. International Law Commission also, in a huge report, almost around 80 pages, confirmed that all members of the international community should comply with the ergonomist obligations. That means that they should respect human rights, they should never discriminate against women, they should never do something genocidal acts, etc., etc. So that has become now, at the contemporary time, in the contemporary international law, as opposed to more traditional international law, there's a firm idea that, as I said, all members of the international community must comply with that. If they don't, the principle of universal jurisdiction will apply to them. So those criminals, for example, from Iran, if they come here to the Netherlands, the universal jurisdiction, you can use it and somehow arrest them and bring them to the court. And there are several other terms that I'm not going to discuss because those are too technical. But the reason why I wanted to present this idea to this conference, as opposed to many social sciences theories that other colleagues presented in the conference, is that I believe that, unfortunately, the Iranian intellectual abroad, those who are so active in social movements and so on, do not know about this kind of huge potential that exists in the contemporary life of us, the life world. There are too many, I want to say, beautiful principles that can be explored if they are able prepare themselves to know, for example, what the ergonomist obligations are, what, for example, use cogence norms are, what the meaning of universal jurisdiction is, and so on, they can easily mobilize the international community and create a very powerful force against the Islamic system, legally speaking, and somehow bring them to the international courts, including, for example, International Criminal Court, at least in some cases such as recent attacks against Baha'is that they want to see them as the genocidal act by the system of Iran. My own concern, again, is that I don't know why Iranian intellectuals, scholars are not interested in exploring of those highly technical, professional topics. And as a result of which, I believe that they have not been really successful in what they are doing in favor of the oppressed people, marginalized people in Iran. Thank you very much. I wanted to keep it very short.
Thank you, Mr. Masaeli. With us online, we have Dr. Homayoun Alizadeh, PhD in Social Sciences, former Deputy Head of Refugee Department of the Australian Federal Ministry of Interior, also former Senior Official of the Office of the United Nations High Commissioner for Human Rights in Africa, Southeast Asia, and Geneva. Welcome, Mr. Alizadeh. The floor is yours for the presentation.
Good afternoon. Good afternoon, everybody.
I thank Iran Academia for inviting me to speak to you today on the issue of transitional justice and seeking truth that probably will be relevant for any future democratic government in Iran. It is the desire of thousands of Iranians and family members of victims of violation of human rights to see one day justice and to seek truth. I would like to quote a human rights activist whose family members were killed in Iran. I quote, "The most important precondition for establishing a new society in Iran is the complete break with the current and prevailing laws, ideology, and attitudes which have systematically reacted towards the political opposition and legitimate demand of the people with prison, torture, and executions. An Iranian society can only be free when the institutionalization of democracy, the rule of law, respect for human rights, and social justice is realized. It is not enough to bring those individuals who were responsible for gross violation of human rights to justice alone. It is also necessary to hold the entire system accountable, which is not only based on discrimination and injustice, but it also, for its survival, suppresses and eliminates the entire political opposition. This is the only way to prevent future absolutist governments from regaining power again." End of the quotation. For the illustration, very brief, the current and forward-looking perspectives. One, we have currently widespread human rights violations, including gender-based violence. Second, there are a large number of victims and perpetrators. A culture of impunity is prevailing. And fourth, there is no judicial system in Iran to address violation of human rights committed by state agents. The forward-looking perspective includes victims are recognized, perpetrators are prosecuted, tried, and duly punished, recurrence prevented, basic norms and values reaffirmed, and fifth, rule of law, respect for human rights, and reconciliation is realized. The definition on transitional justice, very briefly. The transitional justice is dealing with the past for a better future. Transitional justice is based on 4 pillars: the right to truth, accountability and combating impunity, the right to a remedy and reparation, and 4, guarantees of non-recurrence. The right to truth is an imprescriptible right of victims and their families to know the truth about what happened to them or their family members. It is a right recognized in several international treaties and instruments by national, regional, and international jurisprudence. I refer to the Declaration of the UN Secretary General in 2011 to annually commemorate 24th of March, Right to Truth Day. It is the state's duty to give effect to the right to know, and this includes to provide truth, to preserve the memory of what happened, to take measures to prevent recurrence, and 4th, to ensure the independent, effective operation of the judiciary, and 5th, to benefit from a truth commission to establish facts on violation of human rights that occurred in the past. The second pillar of the transitional justice is accountability and combating impunity. The right to justice obliges the state to investigate grave human rights violations, to prosecute the perpetrators, and if their guilt is established, to punish them duly. Judicial accountability means not only to be punitive, but also to be preventive and norm-affirming, to respect fair trial principles, and no blanket amnesties to war crimes, crimes against humanity, and genocide. And 4th, we have national, hybrid, and international courts dealing with universal jurisdiction. You may recall the case of Hamid Nouri, the first Iranian case dealt by a Swedish court applying the universal jurisdiction, or the case of a former Syrian military intelligence officer who was convicted in Germany in January 2022 for torture and crimes against humanity. We have hybrid courts in different countries, meaning that national and international judges work together. We have hybrid courts in East Timor, in Kosovo, Sierra Leone, Cambodia, and Lebanon. And lastly, international courts. We had 2 international criminal tribunals for former Yugoslavia, ICCI, from 1993 to 2017, and International Criminal Tribunal for Rwanda, ICTR, functioning from 1994 to 2016. And of course, we have the International Criminal Court functioning since the 1st July of 2002. This slide shows to you the new accountability mechanisms within the UN system. We have 3 new established accountability mechanisms. First, the International Independent and Impartial Mechanism for Syria, which was established by the UN General Assembly in 2016. Second, the UNITAD in Iraq, the United Nations investigative team to promote accountability for crimes committed by Daesh and ISIL, established by the UN Security Council in 2017. And we have the Independent Investigative Mechanism for Myanmar, which was created by the Human Rights Council in 2018. The question as whether the gross violation of human rights that occurred over the past decade in the Islamic Republic of Iran will be subject of any international investigations in the near future has to be yet answered. The third pillar of the transitional justice is the right to a remedy and reparation. It is the state's obligation to make reparation to victims of violation of human rights and the possibility for the victim to seek redress from the perpetrator. We have 5 types of reparations: restitution, compensation, rehabilitation, satisfaction, and guarantees of non-repetition. The fourth pillar of transitional justice is guarantees of non-recurrence. There are 5 points to be taken into consideration. 1, there should be fundamental institutional reforms to ensure respect for the rule of law and human rights. Second, to restore or to establish public trust and confidence in governmental institutions. Today, there is a fundamental lack of trust and confidence between the population and governmental institutions in Iran. Third, there should be an independent, impartial, and effective operation of the judiciary working in accordance with international standards and norms. Those public officials, such as military, security police, and intelligence officers, who are or who were personally responsible for gross violation of human rights, shall not continue to serve in state institutions, the so-called waiting system. Fifth, there should be effective institutions of civilian oversight over military and security forces and intelligence agencies, including legislative oversight bodies. Six, there should be civilian complaint procedures, such as ombudsman, public advocates, and national human rights institutions. None of them are existing currently in Iran. Of course, in Iran, we have this Iran Islamic Human Rights Commission, which is not working in accordance with international standards and norms. And seventh, the last point, there should be comprehensive and permanent human rights training program for public officials and employees, in particular those involved in military, security, police, intelligence, and judicial sectors. During my assignment with the Office of the UN High Commissioner for Human Rights, I carried out human rights training programs for the members of the armed forces, including military, police, and security officers in Rwanda, in Sudan, in Thailand, Lao PDR or Laos, and to some extent in Hong Kong. Because I belong to the first generation of human rights officers that were sent to different countries to implement human rights at the field level. There are 2 slides here on seeking truth in other countries. The first slide indicates truth commissions with different names. The second slide, where I have put purposely 3 democratic countries, showing to you that even these countries looked into their history and human rights violations. Canada, Germany, and South Korea. In Canada, Aboriginal children were separated from their families and parents, and they were kept in the so-called residential schools to indoctrinate the children into a new culture, the culture of the legally dominant Euro-Christian Canadian society. The Canadian Truth and Reconciliation Commission looked into the past from 1872 to 1996. You may recall the recent visit of the Pope to Canada, apologizing to family members of victims. The second one, Germany, where investigations were carried out to look into the consequences of the former East German communist government. And the third, South Korea. In South Korea, we had two Truth and Reconciliation Commissions. While the first commission investigated the deaths of citizens in South Korea between 1975 and 1987, the second commission dealt with incidents in Korean history which occurred from Japan's rule of Korea in 1910 through the end of the military regime in South Korea in 1993. As an example, I would like to refer to the Iran Tribunal campaign. About 80 survivors and family members of victims appeared before the Iran Tribunal in London in June 2012 to testify on gross violation of human rights and to hold the Islamic Republic of Iran accountable for its crimes against humanity. As a step forward, there are two recommendations. One, to continue the efforts made by the Iran Tribunal campaign to collect, to process, and evaluate systematically data on violation of human rights during the different periods of its 43 ruling of the Islamic Republic of Iran in different regions in Iran, including Khuzestan, Sistan, Balochistan, and Kurdistan. Second, to lobby for the establishment of a commission of inquiry by the UN Human Rights Council on gross violation of human rights committed in the Islamic Republic of Iran. And finally, as an epilogue, in a democratic future of Iran, there should be provisions relating to accountability and combating impunity in bringing the perpetrators of violations to account, whether in criminal, civil, administrative, or disciplinary proceedings that have to be incorporated into the Constitution, emphasizing the important role that should be played by an independent judiciary. Thank you for your attention. I will be more than happy to answer your questions.
Thank you, Mr. Alizadeh. We will continue. We will continue with Mrs. Karlijn Founder-Fort, International Criminal Justice and Human Rights lawyer, also representative of Office of External Affairs at Dutch Baha'i Community. Welcome. The floor is yours.
Thank you so much. Thank you very much for inviting me here. I'm very humbled to be together in the panel with such honored speakers. So my background is in international and human rights law. I used to work for the various international criminal tribunals that was previously referred to. And since about 4 years, I've been working for the Dutch Office of Public Affairs for the Baha'i community. And actually, I want to share my presentation by reading a news story that I read yesterday evening in the Religion News Service. In late July, my brother-in-law returned to his home in Tehran from running some errands to find the house upended, his belongings missing, and his wife gone. His wife, my little sister Fariba Kamalabadi, had simply disappeared. For hours, we agonized over her disappearance until the family received a phone call. It was Fariba. Any relief we felt at having her located was instantly dissipated when she told us she was back in Evin prison, Iran's notorious jail for human rights activists and anyone else deemed threatening to the government. My sister is peaceful, humble, and a law-abiding person. This was her 4th arrest. The 3rd resulted in a decade-long prison sentence from which she was released in 2017. In all instances, she has been innocent of any crime. She is, however, a Baha'i. If you follow news from Iran, you may have heard Fariba's name. Roxana Saberi, the American journalist who was imprisoned arbitrarily in Iran, spent some time with Fariba and her friend Mahfouz Sabet, who was also arrested again on Sunday. She recalled fondly how when fruit rations were distributed in the prison, Fariba would take the worst piece for herself, so her fellow inmates would have some decent nourishment. In winter, when Roxana went on a hunger strike in their unheated cell to protest her conditions, Fariba and Mahfouz literally gave her the clothes off their backs to keep her warm. She called them the angels of Iran. I was worried about her during this time, as she was sometimes placed in cells with murderers and drug dealers, those whom the government considered the dregs of society. When I shared with her my concerns, her response astonished me. She told me she did not look at the outer reality or social standing of people, but rather their inner spirit. Each, she insisted, had a pure soul that God had placed in them. As a Baha'i, she felt it was her duty to see their humanity and bring out the best in them. On the 31st of July of this year, Fariba and two other of the so-called Yaran, the friends of the Baha'is, the informal leadership that had formed after the official leadership had been declared illegal by the government in the 1980s. Three of them were arrested again last Sunday, or the 31st of July. All of the Yaran, all 7 of them had previously served 10-year prison sentences. They were symbols of resilience and renowned international prisoners of conscience. The fact that the 3 of them have now been arrested again, together with so many other Baha'is, arrested, detained, had their homes destroyed, is indicative of the current escalation of crimes committed by the government against the Baha'is, and I'm sure also against other minorities. With the initial wave of persecutions following the Islamic Revolution that we heard more about earlier today, the government changed its method of persecution and became more sophisticated, thereby trying to mislead the international community in detecting the human rights violations. Now, at this moment, Baha'is are systematically denied employment in the public sector, and in many private sectors, they're barred from entering university, subject to misinformation and hate speech by the government and government-sanctioned media. Many are subject to criminal prosecutions. Hundreds have been imprisoned, and many more arrested because of their faith. Confiscation of property, demolition of houses, destruction of Baha'i cemeteries, all form methods of the government's current methods of persecution. On the 22nd of June of this year, Samin Ehsani, a specialist in child education, was arrested and transferred to Evin prison. Earlier in 2011, she had been sentenced by Branch 28 of the Tehran Revolutionary Court to 5 years in prison under Tazir law on the following charges: 1, propaganda against the regime; 2, activities against the national security; and 3, membership in the perverse Baha'i sect. That sentence was later confirmed by the Tehran Court of Appeals, and only now, 10 years later, has she been arrested to serve her sentence. While she was arrested in 2011, she spent 1 month in solitary confinement in Evin prison, but she was then released on bail. Ms. Ehsani had previously provided educational assistance to Afghan children deprived of the right to study in Iran by holding educational classes for them. The teaching of the children was one of the charges against her in court and formed the basis of the court verdict. This is just one story, and there are many, many, many more to tell. And they're not restricted to criminal prosecutions. I know of Baha'is who, and perhaps you also know many stories, but Baha'i children in school who were not allowed to drink from the same tap as the other children because they were dirty, unclean as Baha'is. Baha'is who had shops, who had to close their shops, they were sealed off because they were closed on a Baha'i holy day. And of course, many Baha'i students who cannot enter university, even though they might have ended as the first in their class. Only this summer there have been 60 of such cases. Why are the Baha'is so severely persecuted in Iran? And I think to answer at least part of that question, because I don't know the whole answer, but I have to say a little bit about the background of the Baha'i faith, which dates back to 1844, when a young man from Shiraz, named the Bab, or the Gate in English, announced that he had been sent by God as a messenger of God to prepare humanity for a new age, and also to prepare humanity for someone who would be greater even than himself. Soon, the Bab had many, many followers in Iran, but his message was seen as heretic. And soon, some 200,000 of his followers were massacred. And on July 9th, 1850, the Bab himself was publicly executed in Tabriz. Baha'u'llah, the creator of the Baha'i faith, was the messenger promised by the Bab. And he was born into a noble family. In his mid-20s, he declined a life of privilege and became one of the leading disciples of the Bab. When Baha'u'llah was 36 years old, he was banished from Iran, starting 40 years of exile. It was during his stay in Baghdad, in the Ottoman Empire at the time, that Baha'u'llah announced that he was the messenger of God foretold by the Bab. This was in 1863. Ottoman officials later moved Baha'u'llah to Palestinian territory at the time, the city of Akka, which is currently Israeli territory. The message of Baha'u'llah was one of unity and peace, predicting the creation of world peace as an inevitable, something that will happen in the future, not something that is utopian, but realistic utopian. And Baha'u'llah specifically advocated for racial unity, gender equality, the harmony of religion and science, and many other principles. The Baha'i community in Iran has always had an attitude of constructive resilience towards the oppression. Baha'is are required by their faith to avoid active involvement in partisan politics and to show loyalty and obedience to the law of the government where they abide. And given that unity is the most central element in the Baha'i faith, Baha'is want to pursue that, even under the most dire circumstances. So coming back to the question of why are the Baha'is so severely persecuted in Iran, Baha'u'llah claims, and the Bab, that after Muhammad, the seal of the prophets, God has sent another messenger to humanity. And that God will continue to do so in the future. And this goes against the Shia interpretation of Islam, which says that Muhammad is the seal of the prophets, i.e., he is the last one. And this belief in the finality is the main justification used by the regime for the persecution and discrimination of the Baha'is. In 1991, a secret memorandum was issued delineating the Iranian government's policy towards the Baha'is. It had been drafted by the Supreme Council of Cultural Revolution and approved by the Supreme Leader Ali Khamenei. It states that the government should block the Baha'is' progress and development by means such as denial of university education, denial of employment, and preventing them from reaching positions of influence. And while the memorandum recognizes that Baha'is should be allowed a modest livelihood, the policy has in fact led to what the BIC, the Baha'i International Community, has referred to as economic strangulation, depriving ordinary Baha'is of a normal livelihood. Supreme Leader Khamenei has issued a fatwa discouraging Muslims from interacting with Baha'is and referring to them as deviant and misleading. Now, when we look at the legal background of this discrimination and persecution, we see that Article 4 of the Constitution provides that All laws and regulations must be based on Islamic criteria. Article 19 of the Constitution reads, all people of Iran, whatever the ethnic group or tribe to which they belong, enjoy equal rights. Color, race, language, and the like do not bestow any privilege. Religion is left out of that, which forms a basis for the discrimination of them. The so-called religions of the book, Zoroastrianism, Judaism, and Christianity, are officially recognized religious minorities and afforded certain rights accordingly. We have to be aware that wherever the authorities mention religious minorities, they exclude the Baha'is and several other religious minorities as well, because they are not considered by the Constitution religious minorities. A further effect of Baha'is being considered less by the law is that crimes committed against them are less diligently investigated and prosecuted. Many of the criminal charges used in courts against the Baha'is contain the allegation that they are spies of Western powers. And this allegation dates back to the time of Khomeini, when Baha'is were already referred to as spies for Western regimes. And often the allegation is specified as spying for Israel. Never has any evidence been offered for this allegation. Let me make that clear. Other than the fact that the headquarters of Baha'i International Community are based in Haifa in Israel, near the location where Baha'u'llah had been banished to. And at the time part of the Palestinian territory. The question why such a high percentage of the Baha'is would be spies, what they would be spying on for Israel, and why Israel or other Western powers would select so many people from the most hated community in Iran to be actually their spies remains a question. As I said at the beginning of my presentation, the current situation is really escalating, and I think it is occurring to more minorities in Iran at the moment. In the last 3 weeks, since the 31st of July, the recent crackdown began with a wave of arrests, violent destruction of homes in the village of Roshankou in the north of Iran. On that same day, the Iranian Ministry of Intelligence accused the Baha'is of colonialism and of infiltrating kindergartens in an appalling act of hate speech. It was revealed later that on the same day, Iranian security agents had staged and filmed a fabricated scene in a kindergarten in an attempt to incriminate and frame the Baha'i community of these allegations. They basically gave Baha'i materials to non-Baha'i teachers. The Iranian intelligence service gave Baha'i materials to non-Baha'i teachers and told them to say on camera that they had actually received that from Baha'is, and then filmed that whole process. And we don't know why they've done that. They haven't shown it on national television yet. We don't know what's going to happen with that information. Given the many, many years of this disinformation, hate speech, propaganda against the Baha'is by the regime, many people in Iran have prejudices against the Baha'is. But what we do see now is that the world is opening up. Internet becomes available to so many people. And we see that the Baha'is in Iran get a lot of support from their fellow Iranians, which is such a big inspiration for them to continue their struggle and also their work for the Baha'i faith, which really is the same as what we do here in the Netherlands, is, you know, to help the people around us, to create communities that help other people and to serve our country. Thank you very much.
Thank you. I want to thank all of you for your very interesting and insightful speeches, and we're going to carry on with a Q&A session where I encourage all of you to ask any questions that you might have.
Hello, thank you so much for your interesting presentation. Well, Dr. Karlijn, sorry. My question is, as you smartly mentioned about the Baha'is' situation, especially in regards of their educational system, and we all know that they might get education, but they cannot get officially graduated, especially from the university. I want to ask you if there is any possibility or any chance to, or if there is any attempt to ask for the international platforms to opening up, for those Baha'is who are escaping from Iran, to actually, let's say, verify their education. Because I know so many Baha'is coming to the other countries, and they are facing to prove that they've been educated in Iran. So I want to know if you can give us some information in this regard. Thank you.
Thank you so much for that question. I think it's a very relevant one. And actually, I want to give the microphone to someone else who's actually experienced this herself.
Thanks, Karlijn. I'm Sarah Ahrari. I did a study in the Baha'i Institute of Higher Education. I did civil engineering. And due to the efforts of the Baha'i, the External Affairs Office of Baha'is in Canada, I was one of the first students who was accepted to Carleton University in Canada. And I did my master there, so, and that has helped a lot, because what I think the Dean of Graduate Studies did there, by recognizing my degree, or recognizing the university which didn't have any address, opened a great door, because many more have been, that's followed the way. And I think when I came to Netherlands, also based on the I did have a master, but then they recognized also my BIHE, my Baha'i Institute degree. But it is not in every university. Still, especially the universities that receive a lot of students from Iran, they don't recognize the Baha'i, the BIHE degree. So that's still there's a lot to do, but then it has happened. It's also since 2000. I went to Canada in 1998, so it's quite a long time.
I believe that the government of Iran must be forced to lift up all those restrictions. How? The Convention Against Genocide, Prohibition and Punishment of the Crime of Genocide of 1948, the 2nd of December. If you look at Article number 2 and Article number 3 of that convention, a certain kind of actions has been listed on the roster of all crimes, all defined under the banner of genocide. The Iranian government of that time has accepted the convention, has ratified the convention. The convention is now, even now, part of the internal legislation in Iran, even goes higher than the internal aspect of legislation in Iran. That convention is there. The Islamic government has not at all announced its own willingness to withdraw from that convention. So Iran today is obliged, based on that kind of treaty obligation, to open up our doors to the Baha'i people. What is the problem? The Convention Against Genocide, that fully covers the current condition of Baha'i people in Iran, can somehow be pushed somehow toward some layers of international criminal law to bring that international human rights law aspect of genocide to international criminal law. And if the Iranian activists, I say intellectuals and others, know about these things, they can create a massive pressure on the Iranian government via the non-Iranian institutions. The problem is that in most of the crimes that are happening in Iran today, again, I want to say that Iranian activists living abroad, social institutions, and others are fully ignorant of all these legal instruments that are there available right now, and they can be explored. We can easily bring those things, such as the convention or things that I already tried to very quickly explain, we can bring them to the attention of the non-Iranians, even the government, and create a huge, huge pressure on the, for example, the government of the Netherlands or the other members of the international community, and somehow force them, the Iranian system, to give up. But sadly, the activists are not interested in exploring of those beautiful things. Sorry about that.
Maybe the problem is because the regime is not implementable. I mean, for instance, we have so many rights for women that we can follow up in even the Islamic legislation, but there is no any space for this regime to go and help them.
There are mechanisms. Look at, for example, Article 4 of the Charter of the United Nations. Article 4 says that if one state is going to be the member of the United Nations, that government or the state, let's say the state now, because Iranian model is the kind of state, not the government. So that state must fully accept all rules or purposes of the United Nations and must be willing by the good faith to do all due diligence, for example, in fulfillment of its own obligations. So according to Article number 4 of the Charter of the United Nations, it is possible now, I believe, I want to make this claim, and I can stand say, yes, I'm right, that somehow kick off Iran from the United Nations. It is possible. Legally, it's possible. But my point is that those, I would say, beautiful aspects of international law, international human rights law, international criminal law, unfortunately are none for the Iranian community. And the Iranian community is not interested at all to explore it. And that is why the political system in Iran is causing all those problems for all of the Iranians, including, of course, the Baha'i people. There are some, I want to say, as I said at the very beginning, there are some good opportunities. If you look at international legal instruments, there is a lot that you can explore. If you know them, you can explore them, you can mobilize the international community against the Islamic system, and in the end, the Islamic system will give up if they know what to do, how to do. That's my point.
Thank you. Any other?
Follow-up on your comment. Do you think that the Baha'i community living abroad has that awareness?
No. I think that my point is that there are many legal instruments that are binding. And the bindingness of those legal instruments are driving from the treaty duties of the states. So the state of Iran today, the Islamic State, is obliged to comply with those obligations. But Iran system doesn't care, because Islamic mentality doesn't care at all what is those obligations about. The problem again is that our friends, social activists, networks, and so on are not aware of what is available right now in the field of international law and how we can enjoy them and make cases against the Islamic system. Unfortunately, they do not know.
Thank you all. Thank you.